Hello and welcome to episode 28 of the Legal Scoop, our webinar series here at LOMAD. I'm your host, Brendan Shannon. I'm an associate attorney here. And today is actually the first episode in our rebrand where we're going to talk about recent decisions from the Court of Appeals or the Third Department. So instead of talking about the sweet wins of LOMAD, we're going to talk about some wins and some losses at the Third Department by anyone who's handled those cases, but basically just talking about these cases to get an idea of the developments in the law. So today we wanted to talk about a decision that came down on January 30th of this year at the Third Department, and this case is the Johnston case, which is Johnston v. Howmet Aerospace, Inc. And for those of you who aren't familiar with it, I think you'll find this one somewhat interesting, if not a little bit disappointing. This is a scheduled loss of use claim where claimant's doctor came back, for the shoulder by the way, claimant's doctor came back with an extremely high scheduled loss of use opinion, something that I think we're all familiar with, 70% scheduled loss of use of the shoulder. And the IME doctor, interestingly, said that the claimant was not at MMI. After that, the claimant, and this is kind of unique, submitted an affidavit stating that she's at MMI and that she doesn't intend to pursue any treatment. So at that point, the workers' comp board judge considered the issue of scheduled loss of use, and ultimately the judge and the board awarded the claimant a 50% scheduled loss of use after it discredited the treating doctor's 70% opinion and adopted 50% opinion based upon the claimant's range of motion at 2 visits leading up to the time of permanency, because this is a situation where the claimant went to be seen for permanency by her doctor and she had way worse range of motion than she had leading up to that date. So this is something that we see all the time, and there's tons of board panel case law that will tell you that when a claimant does that, the doctor's opinion on scheduled loss of use is not credible, and we have used that to argue that the prior range of motion measurements should govern and should be used to calculate the claimant's scheduled loss of use, or sometimes we might use those prior measurements to bolster our IME's opinion on scheduled loss of use because perhaps those prior measurements are more consistent with our IME's measurements. Anyways, this went up to the Third Department, and basically what ultimately happened was the Third Department concluded that it was totally fine for the board to discredit the treating doctor's pretty excessive scheduled loss of use opinion when considering the fact that the claimant's range of motion considerably worsened leading up to the time of the permanency evaluation. And the court noted that none of the doctors, neither the IME doctor nor the treating doctor, ever discussed why the claimant's range of motion might have increased the way it did. However, and this is where we run into some trouble because, like I just said, we like to argue that a scheduled loss of use opinion should be calculated by the proper application of the guidelines. And sometimes we'll use prior treatment notes to say that this was the claimant's range of motion, apply that to the guidelines. Instead of a 70% scheduled loss of use, it's in this case a 50%. But here, the court held that it was improper for the board to award a 50% schedule off of the prior range of motion measurements that it cited in this case, which were from visits leading up to the permanency date. And its reasoning is notable here because that tells us where we can potentially find some distinctions. So here, the reason that the court took issue with this approach by the board was that the range of motion was recorded, the range of motion that they relied on was documented when the claimant was not at MMI, it was not long after the claimant had undergone shoulder surgery, and it was not done in accordance with the guidelines. And what they mean by that is that the doctor at the time that, at these visits leading up to the C4-3 eval, wasn't taking 3 repeat measurements, using a goniometer, et cetera. So the key here is that it could be more difficult to argue, as we've done plenty of times here and anyone on our side of the bar has done, to argue that the proper application of the guidelines supports a lower schedule loss of use opinion, or a different schedule loss of use opinion than what's being offered by the treating doctor. And sometimes we even do this with the IME doctors. And it would be a lot harder to do so if we're trying to base it off of prior range of motion measurements. Now, there are some distinctions, however. So just because this case is not exactly great for how we can litigate schedule loss of use opinions, there are distinctions. So for one thing, it's always good to get a treating doctor's opinion on schedule loss of use found to not be credible. A lot of times, the IME doctor might see through, any symptom magnification, issue an opinion on schedule loss of use that is more consistent with where the claimant's condition likely is. So if we're able to show that, there's been this increase in loss range of motion, and that the treating doctor is not credible, that can give us ammunition to argue in favor of our IME. But in situations where both are messed up and we want to argue proper application of the guidelines, we're going to need to distinguish it from this case. So for one thing, it might be possible that if we were to get IMEs on degree of disability leading up to permanency, in a case where that's warranted, to ask that the doctor perform the range of motion measurements consistent with the impairment guidelines. So 3 repeat measurements, using a goniometer, and just making notation of what the highest range of motion of those 3 repeat measurements is for each plane of motion. Then, if you were to point to prior evaluations in the field, you can say, look, the claimant's range of motion was at this time, and that examination was actually conducted consistent with a C4-3 or a permanency evaluation by an IME, and is a credible indication of the claimant's range of motion. And then the other distinction would be, not every case is going to be like this one, where it's short, the prior medicals that are being relied on to show that the claimant's range of motion unduly increased leading up to permanency. There will be cases where it's not that it's been shortly after a surgery, or it's been a while and, perhaps the claimant's barely undergoing treatment, occasionally following up, is working. Things like that sort of show that maybe the claimant really was closer to MMI back a few months before they actually obtained their opinion on permanency. So distinctions like that could help us be able to still argue for the proper applications of the guideline, because this case is very specific on what they factored into their decision to find that it was wrong for the board to create or calculate its own schedule loss of use opinion based on prior range of motion measurements. So there are definitely ways around this. It's not our favorite decision from the court or the third department, but there are ways around this. There's no reason to assume that this is just a blanket statement that the proper application of the guidelines cannot apply. Again, we would just recommend asking the IME doctor to conduct examinations consistent with the permanency evaluation, regardless of the issue at hand. And then also just consider whether there are facts that would support a finding that, the claimant was really closer to MMI at these prior degree of disability evaluations. It's not shortly after surgery. It's not a situation where there'd be any indication that the claimant's range of motion wouldn't be somewhat consistent with where they're at the time of permanency. So that's it for today. We'll be back next month, probably with a case from February, maybe March. Hopefully this helps you have an idea of where things are currently at with workers' compensation law and decisions from the third department. If you like this video, please subscribe below, and we'll see you next month.